California True Crime is a podcast that sometimes deals with heinous acts of violence towards other individuals. This podcast may not be suitable for everyone. Listener discretion is advised.
Welcome to this episode of California True Crime. This is another episode where we're going to cover a topic in the news and discuss some of the legal issues. And this is a topic we've covered a few times, and it always highlights some differences between us. And I think some issues we're still trying to figure out, and that is juvenile justice. Here for this episode are two people you know, Sean and Charles. Sean, how are you?
I'm great. It's great to see you guys in person again.
I know. Charles?
I'm doing great. Yeah, I think we should probably say that this is the first time that the California True Crime team has been together in the same room in over a year. So
Post COVID, we're back.
Yeah.
No more computer screens.
At least for now. Hopefully,
Yeah.
hopefully for a while.
Right.
Before we begin today, we want to give a very large thank you to our Patreon supporters who stuck with us all year while we've been trying to figure out how to keep going. Charles, do you want to thank everybody?
Yeah, we want to thank our current Patreon supporters, Miss RHIB. Sorry if we're mispronouncing the name. Harriet, James, Colleen, Aaron, Brian, and Kim. Thank you all for your generous and continuous support of California True Crime. If you'd like to support us and help our research and production of this show, you can find all the information on our website at CaliforniaTrueCrime.com, on Patreon.com/CaliforniaTrueCrime. Patreon supporters get access to our ad-free content early, as well as stickers and other special offers. But our Patreon supporters have been amazing from the get-go. We've actually had an opportunity to meet a couple of them, which was really cool. And they really do help make this show what it is. So we really want to thank them for everything.
So as I said, we're going to be talking about juvenile justice, and in particular, a Supreme Court decision that just came down in April. On April 22nd, 2021, the Supreme Court of the United States decided in a 6-3 decision that reversed previous court precedent on juvenile sentencing. The crux of this decision decided, and this is according to the Washington Post, quote, that a judge need not specifically find a juvenile murderer beyond rehabilitation before sentencing him to a lifetime in prison with parole. So this sentence won't be changing a lot of things, or really much of anything in California. It will have some effects in other states. So much of how this works in reality is up to the states and varies accordingly, and we're going to talk about that. But in general, the court had determined that a judge should consider something called, quote, permanent corrigibility before making a judgment that a minor should ever be put in jail without parole. So that was limited to very specific cases where someone has committed a violent crime, usually murder, and they're trying to decide what should be the best punishment. And judges often, and especially here in California, take into consideration their past, whether or not they've committed crimes before, whether or not they've tried to rehabilitate before. And this decision says that it doesn't have to do that anymore. That won't affect states where that's already on the books and it's law, and we do that. It will affect, of course, the court case that the Supreme Court looked at, which we're going to discuss in a minute. So that will be limited to very specific cases and in very specific places. But because we're always talking about juvenile justice, I thought we'd talk about it here and kind of go through it. The court decided that based on the 8th Amendment, which is the Cruel and Unusual Punishment Amendment, which the court is always trying to decide what is and isn't cruel and unusual. In this case, they decided it was not cruel and unusual to not take into account the mitigating circumstances or permanent corrigibility before making that decision.
So that's saying, if I'm understanding this correctly, that doesn't mean a judge can't or won't take into consideration a suspect or a person who's convicted of a crime's past. Which means they don't have to.
Right. The case that we're going to be covering actually happens in Mississippi. This is the one that ends up at the Supreme Court. In California, part of our law is that they do take into consideration, and we're going to talk about some of the cases we've covered and talk a little bit about how judges in those cases did that. In Mississippi in particular, they had not taken into consideration in this particular case. And when it comes to states doing different things and they go to appeals, two appeals courts had said different things. One had said you had to take into consideration, and one said you didn't, and the Supreme Court, kind of overarching all that, had to make a decision. So a lot of what I read said that this won't really change too much in most of where we live, because a lot of states, and we're going to talk about that too, I think, already have those kinds of laws on the books. But obviously in this case, it's a real person, so this will affect him and any other states where they prefer not to look at that when sentencing.
So I think it's important that before we go any further too, we really define to start out with what we mean when we're talking about juvenile, or what it is that the justice system considers a juvenile.
Well, I have this chart from juvenilecompact.org, which it kind of goes over state by state, because this is the federal, but then it can go back to states. And such as with this, it says age juvenile case can be transferred to adult court. With the case that we're talking about, Mississippi, they'll actually go all the way as low as 13 for the age range. Everyone has like different ones. California is actually 16 from this. I'm not really sure when this was published, but that's what this says. One that I saw on here that was a little odd to me was Idaho. And it says generally 14, the age 14, but certain offenses such as murder, rape, or arson, there's no minimum age. So if you get the wrong judge, an 8-year-old starts a fire, they could be charged as an adult. So with this federal case going to the states, it can be scary for some, because some of these states still do have a very low age on certain things. But I think it all matters, like we are going to talk about and what you brought up. The judge can make an ultimate decision if they're going to take things into consideration.
Well, I think too, also piggybacking on that, is if this is your first time listening to California True Crime, welcome. If not, then you know how often we mention that there's a lot of this time some of these cases or some of these topics come off from off-air conversations we had, and this is one that has, I think, been since we started. I won't say the most hot button issue that we've talked about, but it is constantly one that's brought up when we were researching a case, especially when it's in that gray area of, like you said, Sean, what classifies as a juvenile? Is it 18, 19, is 13 or 14, or how does that work? And I think that's what made, when you brought this up, Jessica, such an interesting idea, is because this one, and we've talked about it for a little while now, going back over the information that you're going to present, this really does get to the heart of a lot of disagreements we've had amongst ourselves, but also in a larger context with different states seeing what is the definition of a juvenile and those mitigating circumstances. Like you said, in Idaho, is there's those 3 big crimes that if an 8-year-old commits that, it's entirely possible that they'll be tried as an adult, and whether that's correct or morally just or what.
I think it's interesting because in some upcoming cases that we're going to talk about, that seems like, and we've talked about this before in other cases, the justice system kind of moves back and forth between wanting to give judges room to make decisions and look at all the circumstances. So you might have, if you commit a murder, you might have a number of years, and the judge can use his wisdom or judgment to decide what you should get. And then people being upset that, people are going free, or you don't think they're getting what they deserve, and then making things, making them like a maximum, like the judge has 0 leeway. And this is kind of similar to that here, but we're just looking at it in the justice system, if that makes sense.
Well, mandatory minimums is the first one that comes to my mind in that, of if I commit a crime and it falls within these categories, then I am automatically going to be given this sentence, regardless of if there's mitigating circumstances or whatever, automatically going to get 10 years.
And there's good things and bad things about both. We could go over those. I think with a lot of, when the judge has the more ability to make decisions, what we see is that judges choose to put certain types of people for longer sentences than others, maybe based on race or age or gender, that kind of thing. And so people think, well, the minimum sentencing, and that goes back and forth. So I just think it's kind of an interesting aspect to this, because it's juvenile offenders, and what do you do with an 8-year-old who's committed such a terrible crime?
Well, it's another layer of complexity, because we've talked so much too about even when you were reading those lists off, the difference between a 13 and a 14-year-old, okay. I mean, it's a number, right?
Right.
And we've all met some juveniles that are way more put together than most adults I know. And vice versa. There's other ones that even at 17 or 18 or 18, 19, when they're classified as an adult, they're not an adult yet. But so it adds another layer of complexity, which is interesting.
It's important to remember that this is a Supreme Court case. So the Supreme Court isn't deciding whether something is moral or whether it's right or whether it should be against the law or whether the law should be changed. They're deciding whether or not this particular law is unconstitutional. So whether or not taking into account mitigating circumstances or not taking into account a juvenile's, history, or if they're able to be rehabilitated, is unconstitutional and is cruel and unusual punishment. And in this case, they decided that it isn't. So you can choose not to look at that if a state wants to.
Yeah, they're not hearing about the actual crime that's being committed. What they're hearing is about the legal precedent and the rules of which those decisions are made.
Right.
So,
and again, this may not affect, this
Right.
really probably won't have an effect here in California. It may not affect wherever you are, but just because we're always kind of interested in having this conversation, we thought we'd take a look at it. So in this case, it was a Mississippi murder case. Justice Brett Kavanaugh wrote the opinion for the court, and it was a 6-3 decision, so he wrote the majority opinion. Justice Sonia Sotomayor wrote for the dissent, and we will have links to those on our website. They're really interesting. But before we get into our ideas and how we feel about this decision and just how we feel about juvenile justice in general, let's go over some of the information in this case. Specifically, the court case is Brett Jones versus the state of Mississippi. And as it sounds, it didn't happen here in California, but because it could have implications in theory everywhere, we're going to talk about it. For the details in this case, I used the Court of Appeals document, and just so everyone is aware, we've used these a few times. There's usually a lot of good information in them, but every now and then they don't quite have all of the facts, or they have missing facts or dates. I've seen ones where dates are completely wrong. So we understand that this is not a comprehensive document for everything that happened, but it is what we use to kind of get details to talk about. I did do some research in the trial using the newspaper just to kind of get both sides and to understand what the defense was. Just wanted to give everyone as much information as I could find, but we didn't really do a deep dive into this like we do our other cases. On August 9th, 2004, 14-year-old Brett Jones murdered his 67-year-old grandfather, Burtis Jones, in Shannon, Mississippi. The biggest issues in this case aren't about who, how, and when the murder had occurred, but about what led to that act. Those are the details that the jury had to wrestle with, and appeals courts have had to look at. Brett Jones did admit to committing this crime, and all of the evidence at the scene puts him there, including witnesses. But the defense he put forth for the murder was self-defense. Now, this isn't the specific legal issue that the Supreme Court takes a look at. That legal issue was actually a Mississippi law regarding the penalties for juveniles who committed murders. That penalty, and the one that Brett Jones received for the murder of his grandfather, was life in prison without the possibility of parole.
And how old is he?
He's 14.
Okay, thank you.
But I think it's important to go over the details of the murder because they're kind of important to understanding the larger issue about how we should sentence juveniles. Brett Jones had just moved to Mississippi to live with his father and grandparents from Florida in late spring or early summer. He was living with his mom and stepfather in Florida prior to that and had begun to have some difficulties. In February of 2004, his best friend was murdered, and according to his mom, this sent him into a kind of spiral. He began self-mutilating, including cutting and burning himself. At one point, he also hit his stepfather and was arrested. He told a social worker that he was hearing voices and seeing things that weren't there, but unfortunately, he didn't have insurance and was unable to get help. He was, however, given a limited supply of medication for bipolar disorder and schizophrenia. He was also tested for drugs and was found to be clean. And I think they tested him for drugs just like he's with a social worker. They're just going to check everything.
So recreational, not his prescribed drugs.
Correct, as far as I know, yeah. And it's also good to know, I never saw anything that said he was actually diagnosed with anything.
Was there any reports that the medication helped?
What I can say is, I didn't see anything that specifically talked about the medication. What I can say is that both his mom and his father said that once he moved with his grandparents and his father, he was doing better. So I don't know if that was medication or just the move. He was in a better environment. There is information that his stepfather was very violent and abusive. So I think he was in a pretty bad situation in Florida.
All around, not just because of internal stuff, but a lot of external things as well.
Right. And it is really difficult to diagnose someone at this age with a mental disease. A lot of people won't even do it because so much is changing. It is also, as you're going through puberty, a common time for these things to come on, but it's so hard to know what's going on in someone's head. And it's really it's so sad that he didn't have insurance, and that was the one reason he couldn't get assistance. At some point after he had talked to a social worker and was arrested, he and his girlfriend named Michelle Austin ran away. I didn't see how they got back home, but at some point they do. And after this, he was sent to Mississippi to live with his father and grandparents. In August of 2004, his girlfriend from Florida, Michelle, who was 15 years old at the time, ran away from home and also came to Mississippi. She would stay with Brett without his family's knowledge. And in fact, Brett's father would later say that he didn't know anything about her. He'd never met her. The most is that he had seen a few pictures of her in his son's wallet, but he never had any contact with her or anything like that. But she was coming and staying in the house at times. She also stayed in an abandoned fish restaurant near where the Joneses lived. On Monday, August 9th, 2004, Brett Jones's grandfather, Burtis Jones, caught Michelle Austin in his grandson's bedroom. According to testimony, he told her to leave his house. She did, and she went to the restaurant that she was living in. Later that day, Brett and his cousin Jacob would meet up with her in the restaurant. According to Michelle Austin's testimony, Brett was very angry and would say that his grandfather was really angry and he felt he was, quote, in big trouble. Michelle asked Brett, quote, what he was going to do, and also asked if he was going to kill him. And this comes from the appeals document. And I think it's really kind of interesting because there's no context to this quote. It's just, she could have said, what are you going to do? Kill him? Kind of like joking. Right. Or she could have said, seriously, like, what are we going to do? Let's kill him.
And she was asking the question to Brett, are you going to kill your grandpa? Not the other way around. Like, what are you going to do?
Because that statement, reading that, could also be, is your grandfather going to kill you? Is he going to kill?
Yeah. I was just more confused if it was kind of like what are we going to do?
Right.
Things are the way they are versus let's actually plan this out or have a conversation about it. And
or really young teenagers just getting so angry and so wrapped up in their own emotions that they're spouting off stuff that doesn't mean anything in the moment.
So that's one of the things I think hearing that testimony instead of reading it would have really made a difference to how I perceive it as a juror or as us. According to Michelle, Brett didn't say anything to that, but Brett did, again according to her, say he was going to hurt his grandfather. On cross-examination, she also said that she was lying because she was afraid of going to jail herself, that she was lying about the conversation. She was terrified that they would hold her responsible for the murder.
So what you're saying is that she made up the conversation about killing the grandfather because she was afraid that as a runaway and living in this far state that the cops might go after her for the murder.
Yeah. Or just scared of the police in general.
Right.
Who knows if she might have had run-ins in her past and doesn't know.
Right. We don't know anything about her backstory.
And it's also, they're young kids. They're probably both, I'm not trying to make excuses for them, but it's intimidating to give testimony and you're involved. And she probably also doesn't want to implicate her boyfriend. So I don't know exactly what the truth is, but at one time she says this happened and another time she said that she lied about it. So later that day at about 4 p.m., Brett would be back at his grandparents' house. According to him, he went to the kitchen to make a sandwich and his grandfather came in and the two began arguing. Things escalated, and according to Brett, who testified at trial, his grandfather moved into his face and began yelling and pointing at him. He testified that his grandfather had never done that before and it really scared him. According to Brett's testimony, he was backed into a corner inside the kitchen, and when his grandfather pushed him, he pushed back. This caused his grandfather to, become even more angry, and he took a swing at Brett. Brett had at the time a steak knife in his hand. He says he was going to use that steak knife to make a sandwich, and instead he stabbed his grandfather with it. This caused his grandfather to come at him even more, and he began stabbing him again, and then Brett grabbed a fillet knife and continued to stab him. Somehow, the two would get outside into a kind of carport area. Brett testified that he tried at this point to save his grandfather's life by performing CPR. This didn't work, and Burtis stopped breathing. Brett would then carry or drag Burtis inside to get him out of the yard. He put his grandfather into a laundry room. It sounded like a room that was attached to the carport, and he shut the door. Brett then used a water hose to clean blood off his arms. He was obviously covered in blood from the stabbing. He threw some of his clothes in the garbage under the sink and then drove his grandfather's car into the carport to cover up the blood spots on the driveway. A man named Robert Ruffner, had been working in the yard next door, would testify that about 4 p.m. he would hear an old man yell out in pain, and then a few minutes later saw Brett coming towards him with a knife in his hand and covered in blood. Brett was trembling and saying, quote, "Kill, kill." This man ran inside to call 911. About the same time, another witness, this time the man who owned the home, Thomas LaCastro, pulled up to his house and saw Ruffner. That was the man who was working in his yard. Ruffner told him what happened, and at first LaCastro didn't believe him. LaCastro saw Brett standing by some bushes in his grandparents' yard, which is kind of next door. He spoke with him and described Brett as pale and covered in blood. LaCastro asked Brett where his grandfather was, and Brett told him he was, quote, "gone." LaCastro told Brett his grandfather had to be there because his car was in the driveway. Brett then tried to tell LaCastro that the blood on him was fake and just part of a joke. LaCastro told him that he knew it wasn't a joke and that it was real. Testimony shows that Michelle came out to the front, and her and Brett stood and paced by some bushes. So I'm not sure when Michelle got to the scene of the crime. They were pacing by some bushes for a bit, and then LaCastro says they eventually left the scene altogether. LaCastro went to the area where they had been standing, and in the bushes was an oil pan filled with blood. He also went to the carport and saw more blood and then decided not to go further into the house.
And the buddy they had with them at the fish restaurant was not there at all?
No,
Okay.
just the two of them.
Okay.
In his testimony, Brett told the court that he and Michelle left the scene to go to a nearby Walmart. This is where his grandmother was. Her name is Madge Jones, and he wanted to tell her what had happened. To get there, he and Michelle went through a wooded area and to a gas station in Nettleton, Mississippi. Both of these towns are in a really rural area, so it sounds like they're kind of going through more like a foresty part of town to get there. There, he called his cousins to come pick him up, and his cousins actually called the police. The police went to the gas station and arrested both him and Michelle. The two of them gave the police false names, and during a pat-down, they found a pocket knife in one of Brett's pockets. One of the officers asked him if the pocket knife was the murder weapon, to which he responded, quote, "No, I already got rid of it." At the home, investigators found Burtis Jones murdered in the laundry or utility room near the carport. They also found blood spatter on the walls in the kitchen, blood on the carport, in the oil pan, as we said, and a mat used to conceal evidence. In the kitchen, they found the fillet knife and a bent steak knife in the kitchen sink. They also found bloody clothing in the kitchen trash and in the carport. Burtis Jones had, according to appeals papers, 8 stab wounds, although some reports say 12. He also had defensive wounds on his hands and abrasions on his body consistent with being dragged. His cause of death was a stab wound to the chest. The funeral for Burtis Jones was held on August 12, 2004. Brett Jones was sentenced under Mississippi law to life in prison without parole at 14 years old. Michelle Austin pleaded guilty to being an accessory after the fact and was given a suspended sentence. In 2006, Brett appealed the decision, citing several things, including poor representation by his prior defense attorney. It appears a lot of things having to do with Brett's life, including a violent home life, that his stepfather was abusive. The other issues with possible mental health problems were never a part of the trial. They were never brought up. During the trial, his attorney didn't have his father or grandmother testify, and both of them, they weren't supportive of murder, of course, but they would have testified that this was out of Brett's character, that kind of thing. During the appeal, both of those people, his father and grandmother, signed legal documents stating that Burtis was suffering with dementia and refused to get help. He had become a different person and had become an, quote, erratic, violent man. They said that things had become so extreme that other family members had stopped coming over.
And this is Burtis's wife saying this stuff.
Correct, yeah. I should say that, though, because this isn't part of a trial, there's never corroborating evidence of that. I believe she also said that he wouldn't go to the doctor, so there might not be those things. But you would have other family members as well saying,
if this had actually went to like a full trial and bringing up witnesses and things like that. Is that what you're saying?
Well, a full trial where you did put, let's say, the grandmother on the stand or the father on the stand.
Right. You could bring in other family members saying, hey, what was Burtis like? Well, he was erratic. He was yelling and got continually more violent.
Right. But they did sign, a legal document, an affidavit saying that was true, which is a pretty serious document. So as part of his appeal. Which
is pretty amazing considering that Brett had just killed her husband and his father.
Yeah. And this happens also really fast for a trial. A lot of the cases we covered, they don't, but this actually does happen pretty fast. So, I mean, they're still mourning the grandfather's life, and it's just a lot to all happen at once, I think. But it doesn't seem that Brett's attorney really used any of that at all. There were also some other legal questions about pictures shown at trial. Apparently, a couple of jurors also had relationships with family members in Brett's family, so they knew this family and perhaps even Brett. The judge in the appeals did not feel that any of those trial issues, even if they were true, would have actually changed the verdict, so the appeal was denied. Then in 2012, the U.S. Supreme Court made a decision that would change juvenile justice. In a separate case, Miller versus Alabama, the Supreme Court ruled that mandatory sentences of life without parole for juvenile homicide offenders were unconstitutional. They said that these laws violated the Eighth Amendment to the Constitution, in fact, violating the very clause we're talking about, the cruel and unusual punishment clause. A second decision in the case, Montgomery versus Louisiana, provided that juveniles who had been sentenced to life in prison had the right to a new hearing. That ruling specifically talked about permanent incorrigibility. Its goal and the discussion in that case was whether or not, without taking a look at a juvenile's background, whether the same things that we're talking about here, whether they, had prior crimes, whether they had tried, someone had tried rehabilitation and it didn't work. All those things had to be taken into account because when you're putting a juvenile in jail for life without parole, you're making a very big decision. The idea is that there are very few instances where that's actually necessary. In most cases, maybe someone's had a tough childhood, whatever it is, but they can be rehabilitated, that we should be doing everything in those cases to try and help the kids. A second decision in case Montgomery versus Louisiana provided that juveniles who had been sentenced to life in prison had the right to a new hearing. So this is basically putting that decision into practice. So in Mississippi, for instance, kids who had been sentenced under the law and had been given life without parole could now get a hearing, and a judge could look at all of the, all the things going on, all the mitigating circumstances, and resentence that person. According to an article by Shirley Smith in the Mississippi Center for Investigative Reporting, while Mississippi applied the new decisions, quote, defense attorneys say Mississippi continues to unconstitutionally sentence and resentence juvenile offenders to life without parole. So they were supposed to do this, but in a lot of cases, they were just kind of ignoring it. Brett Jones had a resentencing hearing in 2015, and a judge resentenced him to life in jail without parole. This was even though more information had come to light about Brett's life. In prison, his efforts to improve his life, he was taking classes, he had a job, all things the court had said, he didn't really need to do. He was there for life. There's no reason for him to improve himself other than the fact that maybe he isn't the kind of person who just commits terrible murders because they like it or because they can't be rehabilitated. In many ways, that sentence ignored the idea that a judge should take into consideration efforts of rehabilitation.
Hey listeners, if you're tuning into this show, 1, you have good taste, and 2, you might enjoy another show that we host called Death by Champagne, the podcast here to keep you up at night. I'm Mackenzie.
And I'm Olivia.
We have topics in all realms. From the reality of true crime to the depths of the occult, we have dozens of episodes to binge that range from hair-raising scares to infuriating miscarriages of justice.
We've covered everything from the origins of Satan to the crimes of an unidentified serial killer in our hometown of St. Louis. Other episodes include tales of unsolved mysteries, murder investigations, disappearances, cold cases, hauntings, folklore, and people in history that are stranger than fiction.
In Season 3, you can join us for a true crime book club, giving in-depth coverage on cases living in the darkest corners of our bookshelves. Our first multi-part series is on the crimes of Gary Ridgway, focusing on his family, victims, and survivors.
So grab your cat keychain, surround yourself in a salt circle, lock your doors, and unlock that phone.
Hail Satan.
And pop some bottles.
Not only had Brett improved himself in jail, evidence was presented that he was not a violent person prior to murdering his grandfather. He hadn't committed any other crimes other than hitting his stepfather, which we know he was in a very abusive situation as a child. So because Mississippi, in theory, wasn't doing what it was supposed to be doing, wasn't following these new precedents, Brett had the ability to appeal to the Supreme Court, and this is the decision that they had to ask themselves. Does the Eighth Amendment protect juveniles from sentencing that doesn't take into account other circumstances in their life, including, if they're capable of rehabilitation? And they said in this court case, in a kind of reversal of what the court's been doing when it comes to juvenile justice, that they do not, that it is not, that you can choose to sentence, in murder cases, a juvenile to life without parole without taking into account, all the other things going on in their life, or whether or not they've been deemed permanently incorrigible, which means you're like a baby Edward Kemper. You're basically someone who's going to commit those crimes.
But to the knowledge of what the federal court said, they are still saying it's up to the state judge to choose if they want to. It's not saying don't.
Right.
Just making sure, because they're not saying absolutely not, let's just get through this. They're saying the judge doesn't have to if he or she does not want to. But
correct.
still.
Or if a state doesn't want to. In this case, if Mississippi chooses to have its law say that's, you get life without parole and you don't have to think about these issues, then that's okay for Mississippi to do. Or any other states that are kind of
like
similar.
I brought up earlier, Idaho, if Brett was in Idaho and he was 8 for some reason and he does this, they could choose to put him in life without parole.
Yeah. And a lot of these changes are actually pretty recent. These ideas about juvenile justice and what we should and shouldn't be doing, even not putting, giving the death penalty was more recent than I expected. I think it was 2005 when that was outlawed. I mean, I'm not saying states were doing that, but that's still crazy to me.
It was still on the table, so to speak.
Yeah, a state could.
I think it's interesting too because there is a maybe not so subtle jab at the idea that life without parole is not cruel and unusual punishment either. I mean, it's saying that that's a viable thing to give a juvenile, which to me is also an important thing to look at, how certain states will deal with that. Minimum sentencing and things like that. If you commit this crime and you're 16, keeping that on the table, because now I have Supreme Court validation that it's not cruel and unusual punishment for me to give that 16-year-old life without parole.
With all this, it's just hard to figure out because you can keep splitting hairs on words like we've talked about so many times before, because cruel and unusual, sure, life without parole, cruel death, life is cruel and unusual too to some people. And then him killing his grandpa, that's cruel and unusual that he did it with 2 different knives. So where does it stop there? I mean, it's so difficult to try to figure out what to actually do or to even think about it.
And I think that's what's important to read these opinions from federal court. The Supreme Court is really to understand that they really are so many times, not just this case, but a lot of these Supreme Court cases, if not all of them, really get down to almost a semantic argument and really parceling out the language of how something is written and then extrapolating that and applying it in a larger sense. And so much of what we talked about is, like you said, Sean, splitting hairs. It's subjective. There is no definition of what a juvenile is that's going to satisfy anybody. Is 16-year-old a juvenile? I would have a hard time arguing that. 16, you can drive. You're in high school. I'm not saying that they're as capable as a 25-year-old or a 30-year-old most of the time, and I probably would refer to a 16-year-old now as a kid. And we have relatives, nieces and nephews and that are that age that I certainly don't consider an adult.
But yeah, and then you say, at 16 they have the privilege to drive, but at 16, we've had this is the discussion we always have. They're not able to vote, drink, smoke. Another thing that because of a news story that's around, a runaway. She ran away from her home, but now she's technically in a way, hunted to go back because she's under the age. You always hear about missing person cases where they say, oh, they're an adult, they're allowed to go off. But if you're a child, you're not allowed to go off. You don't know the circumstances behind the runaway in the first place, and they might have to go back to their family. All I'm saying is that it's hard to decipher an adult and a juvenile with the privileges or not privileges that they have. And then you have this where it's such a big, to be able to do life without parole on a 14-year-old with no chance of, at 14, to figure out, to get a second chance. You have that much life without a second chance of any chance. Parole, if it deletes parole, you go in front of a board and you get to see, were they doing good? Have they changed? It's a bad murder. I'm going to give you another time before you can get parole. But at least, even at they could get to 70 years old and be able to step out. But this has no chance. And it's just hard. It's just hard to think there's absolutely no chance at 14.
Well, and I know this might come as a surprise. I agree with you on this, is that this 14-year-old murdered somebody.
Right.
And it's a terrible murder. That aside, even now, not putting that aside, he committed the murder. And again, not having the research that you've done on this, Jessica, and not necessarily knowing we can't know what was in the judge's mind at the time. But even the idea that if I was a judge sitting and hearing this case, that I wouldn't take into consideration that this child had lived in an abusive household from a stepfather, had already been in trouble for assaulting the stepfather at one point, whether that was a self-defense or not.
Yeah, to be clear though, I think one of the bigger problems with in the appeals at least is that those things weren't necessarily brought into the trial.
I understand
so
that.
The judge, he may not have known these things, probably didn't know that specific information.
That being said, and going back to his appeal of, I didn't have the best representation as a defense attorney, and again, as sometimes is pointed out, we are not lawyers or in any shape or way. I can't understand why I wouldn't have brought up your mental state, the fact that had he talked to counselors in the past. That's all stuff to bring up that I would want to say what my client did was terrible, heinous, and unforgivable. But we need to give him a chance to better himself, to learn from this, to try to come back at some point. He does need to be punished. He does need to go to jail. He does need to do this. But I am with you on this one. Taking away that ability to be rehabilitated, which I actually think this kind of goes into, and it's on that sliding scale of that question of, really, the justice system, is it punishment or rehabilitation? And it's not just not just necessarily with juveniles, but even we've seen this in other cases of that we've read either outside of those we reported on, or even some of the cases when we report on them, is some of these people that are going to prison for the crimes they committed, what's left for them? So am I doing this as a punishment for you, or am I doing this as a punishment with an idea that I, meaning the system, can rehabilitate you so that you can leave prison in a better state and re-enter society? And it's a hard question then with that, because we're talking about juveniles, which by definition for me, that's the point of being a juvenile, is you screw up. I mean, we've all done it. Talked about it quite a bit, both on and off air, we've all done dumb stuff when we were kids. Thankfully, most of us have learned from those mistakes and had the opportunity to learn from those mistakes.
And this is thinking about 14. That could be in between. You just finished 8th grade, which is 7th and 8th grade is a heinous area to be in anyway, going into just thinking these little steps that you go through at 14. And then he has to move all the way across to Mississippi, leave his girlfriend, who then comes to him and then is kicked out again. So much going on into his head. But 8th grade to 9th grade, that's the age that you're putting someone away in prison for the rest of their life.
I'd have a really hard time defending a judge that said, his past doesn't factor into it.
That's another hard thing.
I couldn't. I don't think. I think if I would like to say that if I was a sitting judge and a case like this came in front of me, I would endeavor to take that into consideration when making a decision. But you do bring up a good point, Jessica, about the idea of I'm only taking into consideration what's brought in front of me in trial, correct? I mean, like if the defense doesn't bring it in front of me at trial, then it's not something I can necessarily take into consideration when making my determination.
Yeah, I mean, you're not going to make up stuff, and there are those cases, unfortunately. We haven't covered a juvenile case, I think, where someone's been given life without parole, but there are those cases that you hear about where someone has committed, they're very young, many murders or rapes. And just to play devil's advocate, because I agree with both of you, a judge should be able to take into consideration those circumstances and should be able to look at what's going on in a child's life. We should be thinking about all of that. But I can understand why people would disagree. Murder is, there's no second chance at that. No one else can get a second chance in this situation. And I don't know. I have trouble with the whole idea, I guess, that juveniles commit these crimes because their brains aren't developed or because they're juveniles. And I know that that's all true. It's just this part of me that, most kids aren't going around committing murders. Most kids who get angry aren't going around hurting people. And it just, I don't know.
And I think that's an interesting point, too, because of the idea of, okay, what do we do then? Kid commits a crime, a heinous crime, whether it's a murder, a violent rape, or arson. Let's use those three from what you read from Idaho. And they are sent to prison they're tried as an adult and sent to prison. But what's next? Are we trying to do anything to learn from what caused them to do that? And I think that's an interesting point about the idea of some of those cases where those juveniles have willfully committed crimes, not necessarily because of bad childhood or whatever, but they whatever reason they've committed this crime. Then I would hope that it would be something within the system of maybe not necessarily rehabilitation, but let's learn from this. What caused this child or juvenile or whatever you want to call them to commit this crime, and how can we better understand the situation moving forward so we can prevent that from happening again? Still maybe life without parole. In some cases, it could be the death penalty, but some positivity of coming out of it is because we've learned something new. And I think that's...
And I'm not saying that I agree with that. I'm just saying I understand where someone would.
I understand that too. And I think we were talking about it where hypothetically, for what I brought up, you got these death penalty cases and you let death penalty or life without parole, you let the family decide the sentencing. Because like we were talking about death penalty and I thought, what if the family wants to be able to go visit that person who took a life every week to remind them who they are? And if they get death, then they don't get that choice anymore. But I think all of it is just right. You have to look at both sides no matter what. You have to look at the victims' families. You also have to look at the person who committed the crime and their families. Mm-hmm. You have to look at the whole situation. It's really hard to say, nah, we'll start from the minute that the knife went in to where we start this case, and that's where we charge it, instead of going back and figuring it out.
And on the surface, to me, the first time that you brought this up, Jessica, as wanting to do this particular Supreme Court case, that's the way I read it. The first time was like, oh, I am really, as a judge, supposed to look at the moment the knife enters and everything else is supposed to be thrown out. And it wasn't really until we got into it more and really parceled it out and talked about it, it was like, well, no, it just says you don't have to.
You don't have to, but still, the choice that's there that you don't have to, which is crazy.
Exactly. And really, that then becomes a luck of, I won't say luck of the draw, but like what state you're in, mm-hmm. And really what judge you get. And not that I'm saying that you can't make a rule for human behavior. You can't make a rule for free thought, especially that's the point of us having judges. Is the idea behind it is we have learned people that understand the law in a way that most people don't, and that they are experts in their field that would be able to make a judgment based on evidence presented to them, ideally. But then to kind of give them that little caveat of, well, you don't really need to, don't take into consideration past history. Just taking into consideration what happened this moment.
Right. I wouldn't mind bringing up here that usually when we do our cases and our episodes, we try to stick to factual, not bring in opinion as much as possible. Mm-hmm. And this one is an opinion that we have talked about for years. Mm-hmm. And if you do think we are completely wrong or agree with us, we do have a Facebook discussion page, and we would like to have you join us discussion-wise. There's no need to get on there and call us names if you do not agree with us, but a discussion is discussion to learn more, and find us on our California True Crime discussion page, because this is a topic that we constantly talk about. We'd like to hear, besides like we're just a bunch of mirrors talking to each other all the time, we'd like to hear other opinions too.
I'm with you, Sean. I think this is we've had so many, and I think it's funny too, because again, if you've listened to us for more than just this episode, you know that a lot of the times we'll talk about, especially these kind of cases, is we had almost a 2-hour conversation over this case, I think a week ago or a week ago, depending on when you're listening to this, on just us. And we're always anxious to engage with you and talk if you like or listen or disagree with us. And you can, whether it's the Facebook group, whether it's our Twitter, you can always send us an email to at calitruecrime@gmail.com. So this is one of the reasons why we were excited when Jessica brought this up and said, hey, I want to do this, is because it gives us an opportunity to kind of rethink about this. And especially, and I think you brought this up today when we were talking before we started recording, was the idea, juvenile justice is one of those, especially this kind of case, is one where we start to see that some of our disagreements are overlapping and our positions have changed slightly. I think, again, if you listen to us for more than an episode, you're starting to figure out where some of us lie and what we kind of believe in. So I would, this is an interesting one because it does challenge a little bit of my own personal health beliefs and how I would think about certain things.
So as I said, this really probably won't affect California. I mean, obviously, we're not lawyers, but we are asked constantly to change California law by voting. So, things could change if we wanted them to. But we can take a look at maybe some of our cases that we've done that involve juveniles. I think the first case that we did was the Mark Adams case.
Mm-hmm.
And he got life with parole. So he was due to be paroled at some point. He, of course,
paroled himself.
Yeah, fled jail, and once caught, was eventually killed in jail. But
he was also older. He was 17. 18, right?
Yeah, but still under 18.
True, but I there's so many times, if we're talking about mitigating circumstances, is there a huge difference between an 18-year-old and a 14-year-old?
That's hard because
it goes back to what our depends on the 14-year-old, depends on the 18-year-old.
It also depends on all the stuff that a judge could not look at.
Right.
And hopefully science in the future. I know there's a lot of work being done on the brain and all of that stuff. It just it might just confuse us more, actually, but maybe it will help us understand these issues better. And that crime is a little different. It wasn't self-defense, and it wasn't against someone that he knew.
So if you haven't listened to that episode, just as a real quick recap, Mark Adams was convicted of killing Michael Ridenour in Modesto, California, in the evening at a baseball diamond with an assault rifle. He and a few friends were in the park. Michael Ridenour was there also with some other friends as part of a separate group. Mark Adams came up carrying the assault rifle, fired into the crowd, and killed.
Well, he was there committing robbery with his friends, as they had, I believe, on other nights. And they were trying to rob the 3 boys. And then when that didn't go well, he shot at them and unfortunately murdered Michael Ridenour. And he got, as we said, life with parole. As I said, I don't think we've covered one case where they've gotten life without parole. But that's the first case I really remember where we discussed, I think, juvenile issues and, what somebody should and shouldn't get.
The other case was the murder of Ida Stein, which I think he was
16, I believe.
Okay, yeah. And what was his sentence?
He was also given life imprisonment, but with parole.
Yeah, and that was a rape and murder.
Yeah.
So I think with all this, it's just with the actual case that the Supreme Court did, it's just hard. Another thing that I think is, I brought this up when we first talked about it, and it's family. It's a family issue too, which you said, but at the same time, that shouldn't matter when it's murder. But that, I think, should be put into an account to look at.
Well, and I could be wrong, but I think I've heard this argument used before, is the idea is that when the state prosecutes somebody like that, they're not representing the family, they're representing the victim. And it is kind of sometimes hard. I'm with you. It's hard to separate that.
I don't even think they're so much representing the victim. I think in a lot of ways we've kind of missed the boat on that. They're representing us. They're representing society and the law.
That's why it says the people versus.
Yeah. So they're not really representing. I mean, that's why victims have had to fight so hard for their voices to be heard, because for the most part, the law, it doesn't really have anything to do with that. You've broken one of society's laws by committing that crime.
Well, and in the case of the murder of Ida Stein, because I think this is important to take into consideration too, is that we have Ida Stein's case. If we look at Mark Adams, if we look at Brett Jones as well, these are all three different individuals. We have a 16-year-old that had been in trouble with the law before. He'd been convicted in Ida Stein's case. He'd been convicted of a few crimes and had been in
he had raped someone else.
Right. And he'd been in I won't say a group home setting, but he had been in a detention facility before. We have Mark Adams, who had some run-ins, but nothing major up to that point, even though he was committing
that we know of.
I'm saying, I mean, he had not been in front of a judge and been convicted and gone away to a detention facility yet. He had some run-ins with the local police, as far as we know, and it was reported. And then we have Brett Jones, who he did have a I won't say minor because it's still assault, but he had a altercation with his family.
Family again, yeah.
And again, mitigating circumstances because of abuse. So even those, it goes back to the question of, should past events color how you sentence a juvenile in the court system? And I think, at least I think what we're all saying is yes. I mean, that's an important part.
It's just hard because every human being is their own individual. Every situation is an individual. There's no template to say this, so don't look at this part. And it's just...
And I do think, again, I know we've said it already a couple of times in this episode, but it does bear repeating, is we are not advocating that Brett Jones was innocent or unjustly convicted.
Right.
What we're really talking about in this episode, again, is how the court system deals with juveniles convicted of these heinous crimes. And again, going back to, we're really talking about again, the Idaho 3, is a violent murder, an arson, or a rape.
And with the whole Eighth Amendment, just trying to figure out the wording and figuring out if it's just cruel and unusual that he gets no chance to rehabilitate.
I think we talked about it in the Ida Stein case. We talked about what the judge looked at when sentencing him. We talked about, him looking at past crimes, whether or not they had tried to rehabilitate. He had been through rehabilitation programs that hadn't worked, and he still sentenced him to life with parole. And in that case, he's still in jail to this day. So it's kind of almost like a life sentence, but he hasn't done, in each parole hearing, it's been said that he hasn't done what he needed to do to gain parole. He hasn't participated in programs. He hasn't. But
he had that hope just in case.
Right, yeah.
To do his job, just like what Brett Jones was doing with no hope. He was rehabilitating himself in prison.
Right. In a perfect world, that's the point of parole to me is, and again, as a lay person, the idea of parole is giving that person a chance. You did a terrible crime. Pay your debt to society. Do something to better yourself within the system. And let's give you another shot to go and live your life outside. Like if the state says you've paid a sufficient amount of your debt and you've done what you should, or what we consider you should. Now, this is not an endorsement of the parole process or any of that. That's I think that's another whole series of episodes about certain things that are issues with that system. But I do like the idea that you do have an out, and that there is a group that can look at that and say, in Brett Jones's case is, he's doing what he's supposed to be doing. He's being a model prisoner. He's trying to better himself and make something of his life for whatever it is. Should he have a chance of leaving?
So one thing that we do want to bring up before we end this is that we've talked about the decisions and everything we've made. And another point that we've brought up a couple times on this is judges in general when we vote. And if you have voted, you will see that there are usually judges on the ballot. And a lot of times those are things that we don't maybe think about. We don't do the research on that because we're doing research on props that are super confusing in the first place. And we take a lot of time doing that. So we've talked about it a lot. No matter what your thoughts or preferences or beliefs are, or however which way you vote, you should know what you're voting for. So next time judges come up in California, you can see if they have convicted children before, look at their past record. And if you're okay with that, then vote for them. If you're not, then don't. But at least know who you're voting for, because maybe we wouldn't have discussions like this, because it might be something you didn't want or you did want. And then it's, I guess everyone will always have different opinions, but at the same time, you'll at least know that you're contributing to how it might come out.
Yeah, the same with prosecutors or district attorneys, which are voted for, at least here in California.
I think that's important too, because if you're not necessarily familiar with California politics, we not only vote for our lawmakers and judges and prosecutors, we also vote for like our propositions, which is a lot of our laws that are then put in our hands. So if you live in California, sometimes that sample ballot can be kind of daunting, because there is a lot of research, but there are reputable, well-researched places you can go to that will break it down in ways that are sometimes a little easier to read. I can recommend a few that I use myself, aside from my wife, who is a lot smarter than I am. But that idea of being educated and understand what you're voting for, and not just, it's another box to fill out. And again, like you said, Sean, I think it's perfect, is doesn't matter what side of the aisle you're on or what party you belong to or what your voting beliefs are, is that these, especially judges and prosecutors and district attorneys, these are the people that have a direct hand in how the law is instituted in our areas. And it's very, very important that we understand that those people are beholden to us as well, and that we vote for them. So understanding them is just as important as understanding who your assembly person is, or your senator, or your representative, or your president.
And we're not trying to lecture you, but what you're listening to is us trying to figure that out for ourselves. So it's just a hour of us.
Yeah, a lot of times, most of this is us thinking out loud, and you can hear us rambling.
Yeah, that's why these episodes are usually 4 hours long and have to be cut down.
But the cases we cover really do have, I think, an effect on how we think about things. And so we're always kind of reevaluating that. And so we just thought we'd share that with you guys. And hopefully we'll hear from you as well, what you think.
Yeah, these episodes generally spring out of a long conversation lately over Zoom or on a research session. And, that's a good idea. Let's make that into an episode.
So if you hate them, skip them. We have regular ones coming.
Right.
If you don't, listen and hopefully participate. Thank you to those who stuck with us. And Charles.
Thanks for listening to this episode of California True Crime. For a full list of our sources, as well as more information on not only the Brett Jones case, but the Supreme Court decisions, head over to our webpage at californiatruecrime.com. As we said at the beginning of the show, you can also support us through Patreon. You can find a link on our webpage, or simply go to patreon.com/California True Crime. You'll find links to our web store. If you'd like to contact us, you can find us on Twitter or Instagram and Facebook at Cali True Crime. On Facebook, we have a discussion group you can join to continue on with this discussion about any of the topics that we've covered, or true crime, or California. If you've enjoyed this episode, please leave us a review. We'd like to thank our quality control engineer, Melanie Duncan. This has been recorded at the Snail Ranch Studios. This is a production of Way Grimace.